Now the question is teaching of environmental law. When we take up this matter, naturally, Professor Ishwara Bhatt yesterday just made a mention that there should be a social purpose of teaching any subject. And what is the social purpose of teaching environmental law? This is the fundamental question which I am going to pose today. The second one is why to teach a subject like environmental law? And what exactly its social sensitivity? And what exactly are the different approaches which are adopted in teaching a subject of this nature? Now, when we take up this matter, the first one is what to teach, why to teach, and how to teach, and the social purpose. Now, almost 40 years have been completed since environmental law is introduced as a subject in the LLB as well as the LLM level. Now, there are universities wherein they offer LLM courses in environmental law. Today, it had gone beyond that. Today, they go to the extent of giving an LLM course in climate change itself. Now, when they offer courses on climate change itself with a degree, master's degree, are we teaching at the LLB level proper environmental law, if at all? Now, this is the basic question which was just haunting me when Professor Ishwara Bhatt just raised a few of the issues in his research methodology talk. Now, when we take up this matter, first one is what exactly is the social purpose? When we take up the social purpose of teaching environmental law, I just intend to give you facts and figures so that you understand the point better. Before the convening of the Stockholm Declaration of 1972, the International Commission on Environment and Development prepared a beautiful questionnaire. And this questionnaire, which was prepared by the body, was sent to several states for answer. All the states, the then states in 1972, were asked to reply for this question. And the question was related to environmental law. It started with the forest. What exactly is the forest cover in a state? In that state which received the invitation. How much it was when it became independent? How much acres or hectares of land are actually covered under forest? And what exactly is the loss? And why the topsoil is deteriorating? Because in the 1970s, especially in Assam, because of the heavy rains, the topsoil was eroding. And this was also one of the questions which was put. What exactly are the reasons behind it? And what exactly the status of animal species? How many birds of different kinds you have in your state? And in which area you have the largest number of birds? And which are the species, remember, which are found in plenty in your country? And which are the animals? Now, all these, remember, the questions were asked to be replied by the concerned states. And the concerned states, remember, replied to this. And the Commission for Environment and Development started, remember, making a thorough study of it. And it was alarming and it was palpable. They came to know at least nearing half of it have disappeared from the world. Remember, without animals, because the society cannot live, and animals live because of the help of the other animal. One may eat the other, but then for purpose of help, it is required. And when it was going, see, for example, I can just give an instance. Why during flood or during famine or pestilence, animals come out of the forest and they go on roads? Because there was a time, during the time of Mauryas themselves, Mauryas for the first time, they said they created elephant forests. They created what we call the resource forest. And this elephant forest, which was created by them, was a shelter for the elephants only. And it was a shelter place for the other animals as well. Now, today, what has happened is all these places have been, remember, taken away by the government departments, wherein, remember, huge buildings have come up and it has become residential localities. It is an inhospitable situation. So in such inhospitable situation, remember when the forests have deteriorated, the international community had to call a conference of other states. And having called a conference, remember from June 1st, 1972 to 15th June 1972, it deliberated on several aspects. Having deliberated on several aspects, naturally, they went to the extent of adopting 26 principles. And these 26 principles became the Bible for the protection of environment. That is the sociology behind it. No, it is not for casual talk. It is a serious talk because the environment and the species and the resources are disappearing very fast. And if steps are not taken to protect this, naturally it will lead to dismemberment. Civilization will not exist. It will come to a grand halt. In order to prevent that, these people have taken steps. I just intend to take to you only our three principles which are very relevant for our purpose. Now, one principle happened to be principle 2. Principle 2 of the Stockholm Declaration pointed out that the resources must be conserved. It has to be conserved for the future generation, the generation which come after us. Oh, it did not say like with these words. It was said only after what we call as the report of Brundtland, which came in the year 1985 on sustainable development. It said sustainable development is very much essential. You cannot, remember, use the resources as you want. When once it disappears, it is very difficult to find and conserve these resources. That was principle 2. Then the second one is states should come into cooperation. They have to cooperate with each other to protect and conserve and promote the environment. And then principle 20, when principle 20 is very important from our purpose, it went to the extent of pointing out, naturally, scientific research has to take place in protecting the resources as well as protecting the environment. Unless, remember, we develop, today we say, use of technology. The use of technology is a word which is being used in several conventions only after 2000. But then, in 1972 itself, the international community made use of it. It went to the extent of pointing out and highlighting the use of technology, that is the scientific research has to take place. Now you may ask me, what is this scientific research? Now in the 1970s itself, what has happened was there used to be sea rise. The level in the sea water used to rise. And there were tsunamis which used to take place. And afterwards, remember the summer heat used to go up in Delhi. This year it has gone up to 50. And in some of the Gulf countries, it has gone up to 53. So when what we call as the temperature goes up, and when the seawater rises, and when forest cover disappears, conservation, remember, is eliminated, they give a call that it has to be done. We are going to adopt a convention to this effect. Now, this became naturally a Bible. Now, one other important article which I just intend to speak to you while explaining the sociology of law happened to be Principle 21. Now, why I am saying this is, maybe you are teachers of environmental law, but I am asking a fundamental question. How many teachers, either here or elsewhere, teach Principle 21 of the Stockholm Declaration? Whether it is being taught in the classroom? Now you may ask me, what is Principle 21 of the Stockholm Declaration? Principle 21 simply points out, states have sovereign rights. If they have sovereign rights, they have duties as well. Rights and duties. In the Hubballian classification, you have just, remember, must have understood it is reciprocal and it is correlative. But then if there are duties, there are rights. Now, are you following the duty? For example, Principle 21 clearly pointed out, states are sovereign, they have the sovereign right. But then this sovereign right which is conferred on a state is not extended to harm the sovereign rights of another state. You may be sovereign, but then you cannot harm the sovereign rights of another state was the first fundamental question that is being spoken. So when we speak about this, naturally, if the states are sovereign, they are not supposed to damage the environment of another state. And in the event of damaging the environment, it is answerable for the consequences as well. Now, this was established in a beautiful case. And this case happened to be a trial shelter arbitration case, which was decided in the year 1939 by the Court of Arbitration. And most of you know, in that case, what has happened was in the state of Canada, bordering the state of the United States, just 11 kilometers away from the border of the state of the United States, there was a factory which was established. So when the factory which was established, remember, in the state of Canada, it was releasing Z, zinc, and sulfur. The sulfur dioxide and the zinc and the Z that was released go into the what we call as the Columbian River Valley. They enter into the Columbian River Valley. Having entered into the Columbian River Valley, they enter the state of Washington. Having entered the state of Washington, it destroyed standing crops. It destroyed biodiversity. It destroyed fishery resources. It destroyed almost all the timber which was prevalent, precious timber which was present in the state of United States, especially in the state of Washington. Now, the state of United States got up from its deep slumber. No, it got up from its deep slumber and questioning, we are living in a peacetime. You are not living in a wartime. And in a peacetime, both of us, Canada and the state of United States, are supposed to live in peace. Instead of living in peace, it has established a factory. And this factory releases emissions which come into the state of Washington through the Columbian River Valley and causing damage to so much of property. What nonsense is this? And the matter was referred to what we call as the Ministerial Council. And in the Ministerial Council, the state of Canada agreed, we are not going to harm, it will be stopped. But then the emission went on, continuing until 1937. And at this juncture, the matter was referred to what we call as the arbitrators. Arbitrators just pointed out, now here is a state which has ruthlessly acted and ruthlessly poisoned and ruthlessly responsible, damaging the forests, the timber, the fisheries, the living resources, for which it has to pay compensation. So what does it mean? You have the sovereign right to do what you want. But then this sovereign right is not extended to damage the sovereign rights of another state. That was the principle which came in first. Thereafterwards, remember, there are plenty of cases, because if I start telling it, that will be the only thing which I can keep doing in the whole seminar, in this hour. Now, second, one more case, only one more case I will point out, although there are 10 to 15 cases. And this is also not taught in the classroom. And this is the reason I am just telling you. See, there was a case which came up before the International Court of Justice. That is the reason of telling this. And this case came up before the International Court of Justice in the year 1974. And in this case, the disputes were between the state of France, as well as the state of New Zealand, as well as the state of Australia. Now, state of New Zealand, as well as the state of Australia, go before the International Court of Justice. And having gone before the International Court of Justice, they request the court to stop the explosion of nuclear weapons in the Pacific by the state of France. The state of France had already exploded a nuclear weapon, and it wanted to explode further nuclear weapon for the purpose of experiment. When it wanted to do it, these two states go to the extent of pointing out it should be stopped from exploding further. Because the one explosion which was caused by it intentionally damaged, remember, so much of the rivers, the sea. And the radioactive substances and the radioactive waste have covered the entire Australian and Canadian coast. And it is an inhospitable situation. They further point before the court of law that we come here as the representatives of the global commons. We not merely represent the state of Australia and its citizens. We represent the global commons because it is a matter of urgency that the International Court of Justice takes up this matter to protect the global commons. If the global commons are not protected, remember, the entire universe will come to an end because of these explosions. The International Court of Justice requested the state of France to explain. And the state of France go before the International Court of Justice and asked, in future, we will not carry out. So in future, we will not carry out, stopped the matter then and there. But then in 1991, again, the state of France wanted to have, remember, to explode thermonuclear weapons in the Pacific. Now the state of New Zealand goes to the International Court of Justice this time. Having gone before the International Court of Justice, it requests the International Court of Justice to conduct what we call as an EIA, Environment Impact Assessment. See, why I am telling this is Environment Impact Assessment came in only after 1991. Before 1991, Environment Impact Assessment was not known. So it requested the court to conduct an EIA by the state of France. And the report which is being done by the state of France has to be submitted to the International Court of Justice. And only when approval is given, it is empowered to conduct the nuclear test. Now the state of, the International Court of Justice simply said, we don't have jurisdiction cases of this kind. It wanted to escape. But then there were 3 judges in the International Court of Justice. And who are the ones who are interested to us? These 3 judges, remember, wrote a dissenting opinion. And these 3 judges who wrote a dissenting opinion happened to be Justice Palmer and Justice Veeramantri and Justice Koroma. Now, Justice Palmer, in his dissenting judgment, has simply pointed out, you look to the development of environmental law at the international level. From 1972 to 1992, it had adopted major declarations and several important conventions. You look to the Stockholm Declaration. You look to what we call as the Declaration of Sustainable Development. You look to the early notification which was adopted by the Atomic Energy Agency. Then you look to the other important, the World Charter for Nature. And after the World Charter for Nature of 1992, then you come what we call as the Rio Convention of Declaration and Convention of 1992. Now, these are developments which have taken place, which have established certain principles of international law, which can be called as jus cogens, rule of law in international law, environmental law. Now, I am putting a question to you. These developments, which have taken place between 1972 to 1992, and the principles which are emerged there, is it taught in the classroom? The very purpose of sociological aspect is defeated because the United Nations, especially speaking about the development which has taken place in the world, it was speaking about the damages which have taken place in the world. In order to prevent the erosion of what we call as topsoil, in order to conserve the forest, in order to protect the biodiversity, it has done so much of work. And if this is not taught in the classroom, what is it that you are teaching? This is the basic concern of a student of law. This has to be taught. Unless it is taught, remember, whatever changes which are being adopted into the forest law, into what we call as the 1986 Environment Protection Act, whatever being put in the Biodiversity Convention is completely incomplete. This is the one fundamental point which I just wanted to harp upon. Now, the second thing which I just wanted to say, are we speaking about the importance of the Supreme Court of India? At least, if you look to the decisions of the Supreme Court of India in matters pertaining to the environment, right from, remember, 1986 onwards, and 1986 happened to be the decision wherein the Volga Tellies came in. And after Volga Tellies in 1986, then came Nilikai Achyutan versus State of Kerala. Then came Sachidananda Partey versus the State of West Bengal. Thereafterwards, a series of cases in the area of environment came in. Now, there are writers who go to the extent of pointing out the Supreme Court in protecting the environment has played a wonderful role. And this role cannot be forgotten by anybody. Now, first and foremost, the Supreme Court acted like a player. Now, what do we mean by like a player? No, it played the role of an educator. It played the role of what we call as an impressive role. Now, what is this? What we call as the educative role. If you look to the textbooks of today, both in the undergraduate level and at the lower level, the subject of environment is being introduced. For the introduction of this subject on environment, who is responsible? It is the decision of the Supreme Court of India that is responsible for the introduction of this subject. It played the role of an educator, and it played the role of a policymaker. Now, you may ask me, what is this policymaker? Whether the Supreme Court has played the role of a policymaker. I will give you cases after cases so that you understand the point better. And those who teach environmental law are supposed to know all these cases, which are, remember, pertinently very important in understanding the subject. There came a beautiful case which is known as Jagannath versus Union of India. Jagannath versus Union of India happened to be a case which was decided by the Supreme Court of India in the year 1996. Now, you may ask me, what is this facts? What are the facts of this case? No, it was in Jagannath versus Union of India. The Supreme Court for the first time pointed out and directed the government of India and the Ministry of Petroleum to use unleaded petrol. So if the petrol containing of lead is being used, it is deadly, it is poisonous, and it will ruin the environment. And ultimately, the Supreme Court of India pointed out, from now onwards, please make sure that when you use or when you purify the oil, remove the lead content from it. That is what, remember, it is the educator and it is the policymaker. Now we take another decision. Another decision happened to be the oleum gas leak case, which was first decided in 1985, then again completed its task in 1987. And it is in this case, for the first time, what we call the principle of absolute liability is being fixed. Now, whether any teacher tells this that it is the role of the Supreme Court to educate and the role of the Supreme Court as a policymaker, do you put it this under category? Nobody does this. Just they will say, oleum gas leak case, it was decided like this. So for the first time, the absolute liability is, suppose, for example, if it is because of your conduct, if it is because of your action, if it is because of your negligence, some incident takes place and it damages the environment and some gas leaks out, then it is your duty to pay the compensation and to clean up the environment. Not only should you clean up the environment, but bring it back to the original, remember, status quo of the environment to its conditions. That was done by the Supreme Court of India. Now, the other important cases I just intend to speak to you happen to be, see, for example, there was another case which came up before the Court of Law, Banwasi Seva Ashram versus State of Uttar Pradesh. In Banwasi Seva Ashram versus State of Uttar Pradesh, it was decided in 1981. The National Thermal Power Corporation of India goes to Banwasi Seva Ashram. And most of the people living there happen to be indigenous people. And these indigenous people were made to vacate the land and on which they were living for centuries. And all of them just chased away. And for them, alternative land was not given by the National Power Thermal Corporation, just as it happened in the Narmada Andolan case. So the National Power Thermal Corporation, because of the power they had, Along with the thermal power, they go there and just make the others to vacate. And all of them, poor people, indigenous people, tribal people, they did not have anything. They could not make both ends meet. So in such a situation, what has happened was a writ petition was filed before the Supreme Court of India. This is nothing but the excessive power used by the National Thermal Power Corporation. Before any land is taken, for establishing a grid, it is the duty to see that the people who are living there are properly placed elsewhere. They should be given alternative accommodation. Without giving alternative accommodation, if these people are chased, it is nothing but, remember, a violation of the principles of natural law and natural justice. The Supreme Court, having heard, gave a decision. First and foremost, any decision before it is taken by the National Thermal Power Corporation, it is the duty to see that they are given alternative land. Without giving alternative land, you can't just throw them out. Environment protection and everything is very much required, but then you can't play with the lives of the people. This is what the Supreme Court just said. It is not only a policy maker, it is a very good law enforcer along with the lawmaker as well. Although the law is made by the parliament, some of the decisions, the paragraphs which are being put by the judges have become a true law, true environmental law today. Now there used to be a perennial problem both under the Water Act as well as the Air Act. So the 1980s and the 70s, two acts came in. One happened with the Air Act and the other one happened with the Water Act. Now, always before the court of law, before the Supreme Court or before the High Court, the concerned departments were handling the concerned case, against whom cases were filed. They used to plead, we don't have money and we don't have manpower. All the cases which came, this B.L. Vadhera versus Union of India, a decision of 1996. In B.L. Vadhera versus Union of India, when the case came up before the Supreme Court of India, the parties, the government, represented by the Attorney General or the Solicitor General, whoever it is, they pointed out the department has no funds. And the department has inadequacy of staff. The Supreme Court came down heavily. Having come down heavily, it went to the extent of pointing out, in future, you cannot plead this plea saying that we don't have adequate staff, adequate money. And if you don't have staff as well as adequate money, you have to obtain it from the concerned department of the government. And it is the duty of the concerned officer to do the needful. And you cannot come and plead and waste our time. No more, it is allowed. This is a beautiful decision. And in another decision, the Supreme Court again pointed out that if a particular industry violates the basic law, that is environment law, enacted by the government, stop water. And even after stopping the water, if they continue to carry on, then stop power. And that is how environment law can be enforced. This is not done by anybody. It is because the Supreme Court of India. And a class teacher should be in a position to tell this in the classroom. And if it is not taught, Supreme Court, no, nothing. It is not going to be effective. It will be effective because you have to give the credit to the Supreme Court of India. Because it is an educator, it is a policy maker, and it is a law enforcer as well. I will tell you why it is considered as a law enforcer at a later stage. Now, thereafterwards, there are certain principles which came in, and these principles are again applied by the Supreme Court of India. Vellore Citizens Forum versus Union of India. What is this? Precautionary principles. What is, in the precautionary principle, it said first and foremost, the authorities who are supposed to take decision are supposed to anticipate, then prevent, and then attack. See, the three words that are being used by the Supreme Court. First one is you anticipate, then you prevent, then attack. And it came in, as I just said, in Vellore Citizens Forum versus Union of India. So the precautionary principle, everyone should know about it. And it is fed by, not by anybody else, it is by the apex court. Then there appeared two important cases which I just wanted to harp upon. And the Supreme Court played an important role even in this. One happened to be Damodar versus Municipal Corporation of Hyderabad. Now, what is this Damodar versus Municipal Corporation of Hyderabad? Now, in this case, remember, because of the density of population that was increasing in the city of Hyderabad, the city of Hyderabad had allocated certain land for purpose of, remember, having gardens in the main place of the city of Hyderabad. And this is useful even for retired people because they can spend their time with their grandchildren or great-grandchildren. And it will be a very good atmosphere. The environment will be hygienic and clean. And it is a pollution-free environment. That is why gardens are required in the heart of the city. Now, what has happened was two agencies. One is the income tax department of the government of India, as well as the other department happened to be the Life Insurance Corporation of India, wanted to take away this land. And having taken this land, they wanted to have a housing corporation for the income tax department and the LIC. Now, somebody filed a suit, a petition before the court of law. Here is a case wherein the Corporation of Hyderabad genuinely allocated certain lands for purpose of, remember, having gardens so that the people can spend their peace time in an environmentally friendly area. And this is going to be taken and given to the income tax department and LIC. What is this? The Supreme Court gave notice to the parties. Having heard the parties, first and foremost, it said the object and purpose of allocating the land. This is how you understand the law. The object, the very object of allocating the land and the purpose of allocating the land is to see that, remember, all of the people live in an environment-friendly environment. And if they don't live, naturally diseases will spread. And you are trying to divert the object. This is totally untenable and this is totally unacceptable. Now, after this case, there came another case from Karnataka, S.B. Muddappa versus Bangalore Medical Trust. S.B. Muddappa happened to be Nijalingappa's son-in-law. And he was an IAS officer and he was the cabinet secretary, chief cabinet secretary in the Karnataka government. Now, what has happened was certain lands were allocated by the Karnataka government in Bangalore for having beautiful gardens in a garden city. Now, there was a medical trust. And this medical trust wanted to knock off the land and to have a medical college and a research center in medicine. Now, somebody challenged before the court of law. And having challenged before the court of law, it came up for argument. And when it came up for argument, the Supreme Court, remember, they thrashed the authorities. They went to the extent of indicating, see, the purpose for which the land is allocated has to be given to that body. It cannot be taken by anybody. And here it is given to have to the municipal corporation for having beautiful gardens in certain areas. How can a medical college come there? So they passed strictures and went to the extent of saying that all the government agencies promoting and protecting environment are supposed to protect and enforce environmental law. They are not supposed to divert from their objectives. That is what the Supreme Court pointed out. Now, for example, the other important aspect I just wanted to speak to you. Today, when we speak of environmental law, there are 3 or 4 important developments which have taken place. Now, one is technology forcing deadlines. What is this technology forcing deadlines? Then prevention of pollution from the source. Then polluter pays principle. So these are the 3 major principles which have become part of environmental law. I shall repeat this. One is adoption of new technology to everything. As and when technology comes to reduce pollution, you are supposed to make use of it. Then second one is pollution prevention from the source. And then public participation in decision making. See, in almost all, for example, in the Convention on Biodiversity, public participation is very much essential. Although, if I just go out of the way and speak, 100 or 200 acres of forests are being taken away by one ministry in Karnataka. How this is being taken? When we say the conservation area of forests are deteriorating and depleting, and a ministry is taking up for purpose of using the concerned forest other than, remember, rebuilding the task. But this is not allowed. What is important is public participation in decision making is very much essential to enforce environmental law. Now, thereafterwards, I just wanted to speak to you. This is the second one. One, I spoke to you about the no harm rule. While teaching environmental law, you are supposed to make a study of it and tell the students. Then the role of the Supreme Court as an environmental law policy maker. Then I just intend to speak to you the third one. When I speak about the third one, most important one and a crucial one. See, the Climate Change Convention, first it was adopted in 1992. And thereafterwards, discussion started taking place for the adoption of a Climate Change Convention after 1992 to 2016. 15, it came to an end. 2016, it was ratified and came into force. Now, that means what? You think of the investment that is being made by a particular state in attending and participating in the Climate Change Convention. 1992 onwards, remember, it is almost 24 years. Most of the representative states, whether it is developed or developing or underdeveloped, all of them have gone and participated and contributed their share in the adoption of a Climate Change Convention. Now, I'm just putting a question whether any teacher who is teaching environmental law makes a reference to this. Although there is a chapter on climate change. Now, what exactly are the role which is being played by the Climate Change Convention? And how much money the state of India is going to invest under the Climate Change Convention between 2016 to 2030? Not even one teacher, maybe in the national law school, not even in the national law school. I can rest assured, I know. Nobody makes a mention. What is the commitment undertaken by India under the Climate Change Convention? Remember, they go to the extent of pointing out, we are going to replace slowly and steadily fossil fuel energy by renewable energy. Fossil fuel energy are going to be replaced by renewable energy. The government of India went to the extent of undertaking certain things in stricto sensu. First point is, remember, it went to the extent of adding 5,000 square kilometers of forest cover. Whether any teacher or any student have requested any student to make a study, how much forest cover is added after 2016 to the existing forest cover? It made a commitment. We are going to increase the forest cover by 5,000 square kilometers. This is research. You have to tell the students or you have to study yourself how much forest cover is increased. Now the state of India has made a commitment there. Now we are going to increase the production of 100 mega gigawatts by using solar energy. We are going to increase 60 megawatts, gigamegawatts by increasing what we call as the solar, not the solar energy, but the wind energy. Through 60%. That means what? 60 megawatts through wind energy. Another 10% through biofuel, biomass. And another 5% through what we call as hydroelectric projects. Whether any teacher tells this in the class. And if this is not told, what purpose of environmental law teaching is going to serve? No, these are certain, see, for example, all the representatives of states have made a commitment. Don't be under the impression that it has come overnight. Are you going to make an analysis of what we call the Clean Development Mechanism? CDM, Clean Development Mechanism. Remember, there are PhDs which are being produced on Clean Development Mechanism itself. And we don't make a study, nor you make a reference. It will be simply telling something and coming out of the class which is not going to help any purpose and serve any purpose. For example, in the recent conference which was held in Abu Dhabi, it was held in last December. Our Sadhguru made a statement. And Sadhguru went to the extent of pointing that states and representatives who are multinationals or anybody contributing, remember, for planting trees on either side of the river. He was just making a mention about Kaveri River. Now the groundwater in the area wherein the river Kaveri flows has gone down. Now it is the duty of the concerned state to increase the groundwater level resources. In order to increase the ground level water resources, naturally, trees are to be planted on either side of the river, stretching 1,500 or 600 kilometers. And those who do it should be given carbon credits, they should be helped. And we should invite them to do this needful. Whether any teacher teaches in the classroom, I am just giving you certain instances, just like a tip of the iceberg, so that you understand the point better. This is not done at all. So under the climate change convention, remember, technology transfer, they say. And if the technology is not used, there will be a tax which may go up to 50%. Suppose, for example, you prepare an item by using the technology and you export the goods. And you are using it without, remember, taking pollution-free measures. And if the technology is produced, remember, without pollution-free measures, you have to pay tax when the goods are exported to a foreign country that will charge on your imports. Whether anybody tells? No, this is how environmental law is being taught, and it should be taught in a systematic way in all the countries of the world. Then, for example, take it this way. When we take up hazardous waste, and today it has become a big problem for a place like Bangalore. Now, I had written an article for the Oxford publication, wherein, remember, we had analyzing what was the type of disposal of waste in ancient India. In ancient India, if you look to the Mauryan period, wherein it is being stated, the entire waste which was produced in the ancient India happened to be organic. And this organic waste which was produced, maybe all types of waste, are used as a manure for purpose of what we call as agriculture. And since it was used as a manure for purpose of agriculture, there was no problem relating to disposal at all. Now, are we following the same? Now, if you say this to somebody, he will not accept. Now, today he will say, groundwater. Where was the groundwater pollution in ancient India? Did they have factories of this nature as we have today? So it was, remember, completely organic in nature. And the waste that was produced used only for agricultural crops and in the agricultural fields when it was, remember, planted and plowed. That is how it was done. And all those good things are forgotten. And we, in the name of technology, we destroy everything. That is why man's reckless act of nature have destroyed. Man's reckless act against nature have boomeranged. And it is his reckless act that has come back to him. That is why we see all types of problems in this country. So the last point which I just wanted to harp upon happened to be technology transfer. Now, all the countries point out that the technology which is invented by the developed has to be given to the developing and least developed countries. Now, the point is, remember, have they given the technology which they have invented to reduce the pollution? See, when we speak about environmental law, major complaint is made against China because it releases 28% of the carbon into the world. And the state of the United States releases 16%. And the European Union, the Council of Europe, all the countries, 31 countries put together, they released 10%. And state of India releases 6% of the carbon that is being produced in the world. Now, the point is, all these developed states, especially the OECD nations, go to the extent of pointing out you have to make use of new technology. In every convention, in every international document, they go to the extent of indicating to reduce the pollution at every level. Technology transfer is only the Ramamana. That is the only medicine. But then it is assured, but then the assurance is made is actually broken to the heart. Technology is not transferred in the majority of cases. And even if when the technology is sought, the technology which is being sought by the concerned state was given a second-hand technology. I just wanted to tell you one instance which was written by Vandana Shiva in one of her articles. She was indicating and stating that you might be knowing the Vienna Convention of the Ozone Layer came in the year 1985. And afterwards, in the year 1987, the Ozone Protocol came in, which was signed at Montreal. And both this convention as well as the protocol, when it came into force, remember, it indicated prevent the release of ozone layer, there should be technology transfer. That was simply saying, in your refrigerators as well as in your air conditioners, you should be in a position to say that it is pollution-free. It doesn't have any ozone layer. And this technology, remember, the state of the United States had, the European states had. When two of our multinationals went to the state of the United States and asked and requested the concerned companies, they said $25 million you have to give. $25 million. Remember, the company may not be having even the worth of $25 million. And some of the writers, Vandana Shiva or another person, she was pointing out, it is not even worth $2,500. And you might be knowing, when India wanted the cryogenic engines, the state of the United States refused to give cryogenic engines. They are the ones who speak about the technology transfer. And when you request them, they say, no, we don't give. Now, today, what has happened? We have better equipment than cryogenic, and we have proved it in the Indo-Pakistan war recently. So this is what is happening. And they think if they don't give, the country will perish. The country in future, remember, the scientists and educated people will come in such a way, they will see to it that the country will flourish, but it will not perish. And thank you. If you have any questions, I will answer.